Good morning. Welcome to an oral argument session via Zoom for the Fifth District Court of Appeal. I'm Judge Eisnagel. I'm joined on the panel today by Judge Wallace and Judge Boatwright. We have on our docket our last case, 24-1743 Harp versus Florida. Is that correct?
Yes, yes, Justice.
All right. So go ahead and make sure that you've silenced any electronic devices you may have, if you could, please. And with that, counsel for appellant, if you will let me know how much time you would like to have in rebuttal, I'll attempt to remind you when you get to that point. It is your responsibility to keep track of the clock, but I'll try to help you remember. So if you just want to let me know before you start exactly how much time you want in rebuttal, that would be helpful.
So Your Honor, I'm just 2 minutes. Just 2 minutes for rebuttal.
Okay. All right. And with that, counsel for appellant, whenever you're ready to begin, you may do so.
One moment, Your Honor.
Sure. And counsel, we're just judges here on the DCA,
Oh,
so you can just call us judge or your
appreciate
honor either way. Whenever you're ready to proceed, go ahead.
much appreciated. So, Judge Eisnagel, Judge Boatwright, and Judge Wallace, and may it please the court, my name is Matthew Zahir Kareem, and I represent the appellant, in this case, Mr. Lamond Harp. We respectfully request that this court reverse the findings of the lower court on the following 4 points. First and foremost, and I believe which has the most merit, is that the court erred in denying the defense's 2 motions for judgment of acquittal. That is heard de novo. Now, the 2 motions, one is related to the pills and the weight of the pills and the identification of the pills. 1.1% of all pills were tested, 1.1% of inventory. The other argument that was made is relating to the conspiracy charge. The second point, or the second point is that the state's evidence was insufficient to sustain the jury's findings.
Counsel, how many pills needed to be tested? So you get the pills that are packaged together, right? I think one of them was 100 pills, I believe. Am I remembering correctly?
There was 100 pills. That is correct. Sorry.
Numerous pills, and only one is tested out of the 100, right? So what's your argument? How many of the pills out of the 100 needed to be tested?
So, Your Honor, this is where the modern fentanyl epidemic has not caught up. The law has not caught up to the modern fentanyl epidemic. Specifically, like we take the Ross case. This was done decades ago, and it specifically addresses pills. Now, in those days, pills specifically, the majority of pills that were available that are illicit or sold without a prescription, they are in fact commercially available. In this case, especially in the modern day with fentanyl, these are not commercially available pills. These were not identified by the chemist. The chemist said they all look similar. In this instance, the chemist
Do
said
they all have an imprint on them of K56?
certainly they have an imprint on them,
And
but
they were the same color and shape?
they looked similar. That is a testimony made. That is a testimony made on the transcript. What's different here is these are not made by Merrick. These are not made by Sanofi Aventis. These are pills that are illicitly made, whether locally or made, say in Mexico. Now, what's interesting here is
Was there testimony where these pills were made?
there was not testimony, but that's the point.
That's not an element of the crime. You don't have to prove who made the pills, how the pills were manufactured. That's not an element of the crime.
You're absolutely correct. And I'm going to get to my point right
Yeah,
now.
counsel, I think that's the problem is that I asked you a direct question and you haven't answered it yet. And so it's creating.
Yes, absolutely.
Yeah.
Could you repeat your question, please?
Well, the question is how many pills needed to be tested? Out of the 100,
I
one was
believe
tested. How many?
in this instance, I believe to get the correct weight to be used against my client for sentencing, all of them.
All 100, every single
All
one.
100, absolutely, Your Honor.
So
And
99, if 99 came back positive, They still had to test the last one.
I do believe so in this instance and in this day to get the correct weight.
And that's because
if we
go ahead.
rule that way, will we be the first court in American jurisprudence to require that?
I do believe so, Your Honor. I do believe so. And I'm going to tell you why. Because just like, we take the Ross case, we take the Greenwade versus State case, they deal with cocaine and they deal with individually packaged cocaine, I guess, baggies, for lack of a better word. Now, what's different here is, again, this is a drug a pill is a package, in fact. And, if the testimony of the chemists, there were multiple chemists in this case, if the testimony of the chemists were, oh, well, we looked up a PDR and these are exactly, say, Oxycontin pills made by Merrick, then I do believe then maybe one, and then I believe Ross would prevail
I mean,
here.
counsel, like I think what you're saying is like, look, if whatever, pick your big company that makes
Mhm.
medication, right? Makes pills. Well, I think what you're saying is, look, if it were those pills, that there would be an inference. And you'd only have to test one because there's an inference. Or are you saying you wouldn't have to test them at all? Just no test whatsoever. Is that what you're saying?
So you would have to identify them and have authenticity of the pills. I believe that would require,
Well, you get a pill, it says Pfizer on it. You don't need to test it now, right?
no, you do have to test it if it's in, say, a bottle or a bag.
But
That's
in that case, if it's a Pfizer pill, it says Pfizer on it or something,
huh?
then you only have to test one. Is
Well,
that
I do believe, based on the Ross case, what the Ross case provides, which is kind of decades ago, that the availability of pills and pill manufacturing was not essentially, you could identify those pills. You could test a pill, say, in a bag,
hmm
in I believe the word they use is a packet, or in
Right.
a
Right.
mixture of pills, right?
Yeah.
So if you could identify them as authentic pills from a manufacturer, then certainly. That's not what was done in this case.
But let me make your argument for you. You're saying, I think you're arguing that, look, if the pills are made by Pfizer, you only need to test one because once the one comes back as a positive hit for whatever drug we're talking about, right?
Mm.
That there is a strong inference because these pills are made by Pfizer that they're all the same. It's an inference. It's an inference, right? One pill coming back with a positive result. There's an inference that all of them are. Is that your argument?
That is my argument because we have the FDA,
But
we have
but when
regulation.
it's not a Pfizer pill, and I'm just picking on Pfizer because that's the one that comes to mind, but whatever company, right? It doesn't matter what company we're talking about, but we'll say Pfizer. If it's not a Pfizer pill and it's sort of made in an illegitimate facility that is, under the radar, making illegal stuff, that now is it your argument that there is no inference now? That the inference disappears, that once you test one and it comes back positive, that the rest within that same package, there's no inference that those other pills also contain the illegal drug.
I would absolutely agree with that statement specifically because, we're here, we're on the street. There's a huge, a huge inference that these people selling these pills are there for money. We
Mhm.
don't know if they're counterfeit pills. We don't know if they were made
But
specifically.
but why is there zero inference? Look, I think you could make a reasonable argument that with the Pfizer pills that there's a stronger inference. But why is there no inference?
There's no inference because there's not regulation for the making of these pills from the federal government. We have the FDA that regulates what these pills contain,
Yeah,
what
but someone, what FDA or not, someone gathered all these pills that look similar. They have the same, marking. They're all pink, I think it said, right? They're all the same, whatever it is. They all look the same. Someone took them, put them together. One of them tested positive. Why is there not some inference that requires the jury to decide the weight of? Why is there not some inference now that they all contain the drug that came back positive? Why? Someone took all those pills that look the same, put them in a package, right? Why is there not at least some inference that the jury now needs to weigh?
Because the manufacturing and sale of those pills are not for medicinal purposes. They're for illicit purposes and to make money. Essentially, that's what the point of it is. It's
Mhm.
to sell some sort of substance. You know, in the Ross case, they make the argument here it's the individually wrapped plastic packets of white powder could have contained milk powder, could have contained other substances to look like that drug.
Mhm.
Specifically, you know, in the business of selling drugs, illicit drugs, it's it's not there for medical purposes. It doesn't have to have the same efficacy of a pharmaceutical drug. These are
Doesn't this
like,
really go to the weight of the evidence, not necessarily whether a prima facie case is made? I mean, you get to argue this to the jury, and they only tested one or three pills out of 269. I think that's kind of what Judge Wallace was alluding to, that this doesn't necessarily go to the elements, but in a prima facie case, but rather to the weight of the evidence, doesn't it?
correct, and that's specifically what we're discussing here, which is to the weight. And the weight of the evidence here is, you know, for instance, 1 out of 100 pills was tested. Now, when we think of pills, we immediately think, oh, you go to CVS, you get pills, you get a prescription of pills. These are not those. These are not those.
Oh, hold on,
We lost
counsel.
Mr. Cadwell.
Okay, there we go.
You
Okay,
good?
he's back. Go ahead.
So, I mean, specifically, I believe the analyst said, I can't
Counsel,
say,
if it goes to the weight,
yes,
then why don't you lose on this issue?
if it goes to the weight that was sentenced, essentially here, the sentence should be changed because the weight of the pills, when it's remanded,
Hmm.
it should go to the weight. If they have the pills, they could test all the pills because particularly in the Ross case, the chemist in that case said it was they didn't test all of the packets. They didn't test all of the drugs because of workload constraints.
Hmm.
Testing
Counsel, question. I believe Judge Boatwright's question was phrased in using the word weight of the
a
evidence.
weight of the evidence.
And I believe he's seeking overall the weight of the evidence as I see it is your client was involved in a continuing transaction involving multiple phone calls, multiple show ups, multiple sales, and they were talking about a specific number of pills. And there were, multiples of pills exchanged during these transactions. And it was from one of those groupings that the pills were tested. And it came back positive for exactly the product that the theme of the case was that they were trying to traffic in. So the weight of this case, and I think that's what Judge Eisnagel was touching on too, to me kind of seems overwhelming. Like you test one pill and lo and behold, wow, it comes back positive for fentanyl. Well, okay. Well, what were the other pills? I guess your argument is the other pills were salt pills or just something random, but it seems rather tenuous to me. Can you strengthen your position with regard to those facts?
So, I mean, specifically, I'm going to speak factually here is fentanyl is a very, very strong narcotic. I'm sure we've all seen ads and commercials talking about the dangers of fentanyl. That a minuscule amount of fentanyl can instantly cause an overdose. The same is not true of commercially available pills. So specifically, you know, and again, the purpose of the sales is to make money, not necessarily sell medicine. You know, it goes more towards just like cocaine, right? Cocaine has cut. They talk about that in the Ross case. It's the weight of the drug, of the actual drug. And it's our position that
Yeah,
each of
it's your position that it's more likely with this kind of pill that there's either not as much fentanyl in it, or that there's more, or that there's none. You're saying it's more likely in this situation that one of those pills, if we tested them all, that at least one of them would show no fentanyl in it. Is that what you're saying?
I'm saying there's a very high possibility and chance of that.
Yes, exactly. It's higher than if it's a Pfizer pill. Um, why doesn't that go to the weight of the inference that would be for the jury to decide?
It goes towards the weight of the inference for the jury to decide because in this instance, in this instant matter, it's specifically because the analyst can't say what the other 99 pills are. That's
Mhm.
testimony. That's transcript 706, lines 20 through 25, and transcript 707, lines 1 through 9. Because the chemists themselves say, we don't know what's in the rest of them. I can only tell you what's in these.
Sure.
And I believe
How about
that's
on the conspiracy issue? What the well, what's the other individual who your brief says just aided and abetted because he was only present? Reading the record, it seems like he was more than present, right? It seemed like he knew exactly what he was there to do. He was looking for uh, presumably, or at least there's an inference, he was looking for your client. He was on the phone, right? With the co-defendant. How is it that he was merely, as your brief said, merely present?
so we're talking about, thank you, Your Honor. We're talking about Mr. Calderon, who goes by the nickname of Junior.
Hmm.
So he was only involved in one transaction here.
Why does that matter?
It matters because there's not a pattern. Now we look at
So
eight.
for a conspiracy, there has to be a pattern,
So there has to be an agreement. So
right? There has to be an
aiding and
agreement.
abetting
Right. There has to
action.
be an agreement. And based on why isn't there an inference that there was an agreement? How did Junior know to be there with the inference that he had drugs to sell? He knew who he was looking for. That this is that all the evidence seemed to support all of those things while he's on the phone, right? Getting instruction. How is that not a conspiracy? Or at
So
least evidence that a jury could conclude, right? That's what I mean. Evidence that a jury could conclude.
So I do believe, particularly, and I make it in point two specifically, there's 3 points here. Now, it's the mere presence of the scene of a criminal transaction, which is insufficient.
Mhm.
Second, the rapport, and I do believe the actual testimony and evidence presented at trial shows the rapport between Junior and the defendant, JR, and the defendant was minimal, not conspiratorial. He was transporting or delivering. Those are actions. I don't believe the actual agreement was shown at trial. Sure, there was instructions, but is that a tacit agreement? Is that an agreement? Hey, we're here to make money. You're going to deliver these drugs. I'm going to pay you this. That's not what was
Oh,
elicited.
is it your argument he had to be paid? There had to be
No.
evidence that Junior was being paid?
So when we talk about agreement, or, going into civil law,
Oh,
uh,
it was like a contract. There had to be a contract.
well, there had to be an agreement. There had to be an agreement. And
Like
typically
Had to be an
with
understanding.
compensation?
doesn't necessarily have to be compensation, but there has to be an agreement, a furtherance. Here, I believe the record only shows here action,
Hmm.
action only.
Right.
The counsel was, I believe the testimony was that the CI testified to hearing your client's voice on the phone call when JR Jr. was in the car. Is that correct?
That is correct. There was testimony of that, and that was objected to by the trial counsel for hearsay. And I don't believe that that inference enough on its face is enough to make that. Additionally, we don't know what was actually being said. I believe the transcript stated that the voiceover or what he could hear was minimal and minimal.
Did the jury hear the audio on that video?
They did hear the audio. There was a sidebar relating to the quality of the audio.
So the jury did hear the voice on the other side of the phone call, correct?
To me, the transcript is unclear. I was not the trial attorney. I could not tell you one way or the other, but it seems that there was bits and pieces. It was not on, say, a speakerphone. It was, he heard it through the headset.
But the CI that testified at the trial said that that voice was consistent with your client's voice, correct?
That is correct. The CI who
Okay.
had pending charges and 13 felonies.
So then the jury would then be able to weigh the credibility of the CI who testified at trial, correct?
Certainly towards a conspiracy charge. I would like to reserve the last 30 seconds for rebuttal.
All right. Counsel, we can do that for sure. Let's move to counsel for appellee. And counsel, whenever you're ready, you can proceed.
Morning. Thank you, Your Honor. My name is Dan Caldwell with the Attorney General's Office on behalf of the state of Florida. Your Honors have hit all the points I was planning on making. Do you have specific questions for me, or would you like me to address the points that you asked opposing counsel, specifically the argument of the testing of the pills, weight of the evidence, and mere presence?
Counsel, it looks like there are no questions. How you want to proceed is entirely up to you.
If there are no questions, Your Honor, then the state will rely on its brief, and I would ask that this court affirm the judgment and sentence below in all respects.
All right. Thank you, counsel. Okay, so we're back to counsel for appellants. You have 33 seconds. Counsel, whenever you're ready, you can proceed.
One moment. All right, we can start. I think here specifically, we have to look at the guidance that was given in the Ross case. But the guidance that was given in the Ross case, I do firmly believe that this illicit drugs, they're pre-packaged in a pill. There's no testimony or evidence that these were manufactured or made by a pharmaceutical. And I do believe that there's weight to that, and that needs to be taken into account. Again, I am asking this case to be remanded back for a new trial regarding weight specifically, as well as I rest on my brief and my reply. Thank you.
All right, counsel. Thank you very much. Thank you to both attorneys. And with that, this court is adjourned for today. Thank you.
Thank you, everyone. Thank you, Mr. Cadwell. Be well.